Right. So I would request you guys to put up your queries either in the chat box or in the Q&A box. I would really like to take up questions from each one of you. So whatever questions you have, whatever you could not understand, whatever you want, further explanations on, you can put it down in the chat box or in the Q&A box, right? So we are live on YouTube now, so we'll just begin today's session. Let me introduce you with our today's expert. Today we are joined by Esha Shekhar ma'am. She graduated from NUJS in 2012 and has been practicing law ever since. She has worked extensively in area of commercial laws, criminal laws, and labor laws in Delhi High Court, various district courts and tribunals. She has done pro bono and legal aid work with Delhi High Court Legal Services Committee on protection of women, service and labor laws for more than 2 years. She co-founded Ungender to make workplaces inclusive, safe and legally compliant, and has consulted several Indian and global clients on compliance with anti-sexual harassment at workplace laws. She was also managing trustee at Initiatives for Inclusion Foundation, which filed PIL in Supreme Court to ensure state governments comply with PoSH Act. She led PoSH law sensitizations for more than 30 police stations in Delhi and Haryana, impacting 400 police officials, and conducted capacity building training for about 250 state level officers across several districts of Chhattisgarh. Recently, she has also published a book titled Understanding Workplace Laws for Women in India with Bloomsbury Publishing India and Bloomsbury Professional India. It is a go-to book for information related to workplace laws, provisions for women as per PoSH Act and labor codes. Will know about the book from her later on. So without any further ado, let us start today's session. Thank you so much. Thank you so much, Esha ma'am, for joining us.
Welcome, Akshay. Thank you for such a warm introduction.
Yeah. So before we start the session, I would like to know from you what is the how can lawyers practice in the area of PoSH Act? What are the things do lawyer get to do while practicing this particular law?
Okay. So, you know, practicing in the area of prevention of sexual harassment law compliance is actually a very diverse field because it requires you to be a lawyer, step in the shoes of the lawyer, as well as take up different things in terms of working with an organization in terms of training, providing training to the employees, providing training to the ICCs, internal complaints committee that are set within the organization, and also work as an external member, which basically means that the internal complaints committee that are set up within the organizations, they have internal members as well as they have an external member, and the external member is supposed to be any person who's working in an NGO which deals with women issues, or a person who has the experience handling sexual harassment cases. So the work that is there under compliance of PoSH Act is quite diverse. So when I started with helping organizations implement the laws in terms of, I took on the lawyer's job in terms of making the prevention of sexual harassment at workplace policy, which is a very critical part and a mandatory compliance under law for organizations. So the policy making is important. That's where a lot of work is generated, like documentation around PoSH. So helping the organizations draft PoSH policies, helping the organizations determine what are the notices that need to be put up in the workplace as per the law, filing the annual compliance report every year, every calendar year under the law, also helping the organization do the helping the organizations implement the law with respect with vis-a-vis checking all the HR policies in the organization, seeing that what needs to be done, how the implementation needs to be done at the ground level. So that's part one. Part two of the work that is there is the law says, and the law is very unique in nature. The law says that prevention is something which is the most important part of the PoSH Act. The law focuses a lot on preventive measures. So as preventive measures, the law says that every year organizations should conduct employee sensitization sessions for all employees, so that they understand the law and they understand what to do, what not to do, and details regarding the law. So and it's not difficult for somebody to train as a trainer for this law, but it just requires experience, and that comes with doing different sessions in this area. Another place is because the ICC that is being set up within the organization, it's a quasi-judicial body, given the fact that it derives all its powers from the PoSH Act, and they have to follow the procedure as per the PoSH Act. The law also puts a mandatory compliance on the organization, that they need to make sure that ICCs are properly trained, because they are the ones who are conducting inquiries. And inquiries and investigations of sexual harassment complaints are coming up, actually. Like, a lot of organizations, be it small or be it big organizations, they are receiving a lot of these complaints from women, and that requires investigation to be done on the pedestal of the law, following the parameters that are provided under law. So that is, it becomes very, very essential for ICs to be trained, because most of them are non-lawyers. So that's where, a compliance professional comes in, because they are the ones who are training the ICs as well, in terms of understanding what are the how should they conduct investigations, what does the law say, and details like that. The third part of the work that comes for a professional who is working in the compliance area is working as an external member, as I said, because as one external member is needed in the ICC of every company which has more than 10 members. So every company with more than 10 employees need to set up the IC, and every such IC needs to have an external member. So it's very essential for the organization and it's also essential for the professional who's practicing to do that investigation. So that's where a lot of work gets generated, because lawyers can charge or HR professionals for that matter, because some of the audience is HR professional. It's not specified that the external member needs to be a lawyer. External member can be any person experienced in handling sexual harassment complaints. So there's a lot of work being generated in that area as well, because they need mature, neutral people to come in and help in the investigation, help in the compliance, help in conducting the inquiries. So therefore, it becomes very important that professionals who are working in this area also work as an external member, and external members can charge on a different basis also, because external members are charging on per month retainer basis, they are charging on per hour basis or per sitting basis. So basically that becomes, that also becomes an area where work is getting generated.
Right. So there was a quick question. Does it matters what is the gender of such external external member?
No, absolutely. I can see Venkateshwara's question. He asks that is it advisable to have a male or female expert as an external member? And should there be a balance of gender in the composition of the IC? A great question, Venkateshwara, because sometimes a lot of organizations think that external members should only be females. That's not the case. The law does not specify that external members only need to be females. It can be anybody. So basically it does not define, the law does not define the gender of the external member. It has just happened that a lot of people who are working as external members are women, but I've seen men also being taking up external member training programs, and also working towards being an external member for the ICs. The second question is, should there be a balance of gender in the composition of the IC? Yes, that comes from the law itself. The law says that at least 50% of the women 50% of the composition of the IC should be women employees. So should be women, basically. I'm sorry, it should be women. So what happens here is, I'll just go a little step further in defining what an IC is. As per the law, an ICC should have minimum of 4 members. It could be more, but it has to be minimum of 4 members. The law says that the presiding officer of the IC should be a woman employee, should be a senior woman employee. So that's where the gender of the female of the presiding officer is already defined in the law. But for the remaining 3 members, gender is not defined. So the law says that minimum 50% of the composition should be women. Therefore, it means that 2 people should be women, and rest 2 could be male, could be female, or could be anybody, basically any other employee of the organization. So therefore, majorly, Venkateshwara, what happens in organizations is that because presiding officer is a woman and mostly external members are women, therefore the rest of the 2 internal other members are to be selected. I always suggest organizations to see if they could have male members within the ICs, because that gives a more balanced approach to the ICCs as well. So that's what. So law says 50%, 2 would definitely have to be there. Remaining 2 is the discretion, depending on the organization. Okay. Akshay, any other question that I need to address here?
Just one more question. Why is it necessary to mandate to engage NGO representative? What's the thought process behind it? Basically, why do we need to do that?
Okay, so see the original thought process behind having just to clarify, there is Nirzari. The law does not say only NGOs. The law says that external members can be either from an NGO or an organization that works on women rights issues. And secondly, it says that, or it could be an individual person, but somebody who has experience handling sexual harassment cases. Therefore, you will see a lot of individual consultants like me as well. I am an individual consultant as well. I also work in this area. I fall into the category of a person who has experience handling sexual harassment cases. But the NGO part and the fact that the law says that it should be from organizations which are working on women rights issues, that the original thought process was because a lot of these organizations who are working, and mostly organizations who are working in women's rights issues at that point of time as well and now as well, they have an access and they have an understanding about the practical day-to-day issues that are coming in for women in terms of, and they are handling violence relating to women cases all the time, right? So the idea of having an external member was to make sure that there is a neutrality and there is a maturity that comes with an external member who is helping investigate such cases. So therefore, at that point of time, the lawmakers, the idea was that they have more experience and maturity handling such cases because they have already have an idea handling violence against women cases in other domains. So that was the thought process. I think these were the 2 questions.
Thank you.
Yeah.
All right, so we're talking about ICC and external members. So I would like you to clarify if there is any cost if an organization is non-compliant with such provisions of having an ICC or any other mandatory provision under.
Correct. So very important actually for everybody to remember here, because lawyers and HR professionals are also part of this discussion, that because Prevention of Sexual Harassment at Workplace Act is a compliance act at the end of the day. Therefore, like any other compliance act, there's also a penalty angle attached to it, which means that if you're non-compliant with the act, and what does non-compliance with the act means? Section 26 of the act says that if you are non-complying with the provisions of the act, namely constituting the IC, like, so basically organizations who are not constituting the IC, organizations who are not conducting the inquiry procedure as per the provisions given in the law, or the law goes on to say violation of any other provision of the law, contravention of any other provision of the law, in that case, the law has identified district officers. Okay, and district officers are basically what the state governments have to appoint in every district. Mostly it's the district magistrate or the district commissioner of a district who has the responsibility for the implementation of the act in their district. So the law says that if you're non-compliant, then there is a fine of 50,000 rupees, up to 50,000 rupees for the first act of non-compliance with the law. And the law goes ahead to say that if the organization is found to be a repeated offender in terms of non-compliance, then the fine can be double of the 50,000. That is part one. And part two could be that there could be that the cancellation of license can take place for that organization in whichever field that they are in. So for example, if it's a restaurant, FSSAI license could get cancelled. If it's a factory, the license that they have to take for running of the factory can get cancelled. So that is how stringent the provisions of the law is in terms of the non-compliance. Now, now what has happened is, I like to add one more thing that is there now, is that under the 2018 amendment to the Companies Act, under the Companies Act, and there was a companies rule that got amended. Now what they have done is that they have added it as a provision for, with respect to directors putting the composition of the IC and the fact that they have constituted the IC in their company's board report and the annual report that goes out, annual board report basically. And the non-compliance of Companies Act also gets attracted if you are not putting that details in. So therefore what has happened is PoSH Act provides one penalty, Companies Act provides another penalty, and there is a third kind of penalty which is undefined, which is basically the loss of reputation and brand value that happens for an organization. So if you look at the recent Me Too movement that has started, and with respect to, and majority of the cases have come up against people, senior management or management working in an organization, you will realize, and not just the Me Too movement, whichever case you will hear which did not do their investigation properly or could not provide a woman a recourse, proper recourse that was there under the law, in that case, it just because everybody has an access to an information portal these days, people are putting out information, people are more aware, so these details are coming out much faster. And when the details come out much faster, then the organization's reputation is at stake, because once it gets hit in terms of making an information coming out that your organization is not providing for the safety of women, then there is a certain brand value that gets hit. So rather than going into and figuring out how to circumvent the law, this is one of the essential laws that need to be there at the workplace if you want to make sure that you want to come across as an organization that promotes safety and well-being of their members, especially women in the organization, given the fact that the law is geared towards protecting women employees.
Right. So
yeah,
one follow-up question is there.
Yeah, I'm seeing the question. I'll just Akshay, I think you're talking about Nizari's question, follow-up questions, right?
Right.
Yeah, let me just, I can just see it. Let me just address it once. So Nizari, of course, there is the risk of key details about the organization in terms of the IC formation and in terms of the information regarding the investigation going out. But obviously what you do is you sign a consultant engagement letter, or you sign an NDA or some form of agreement with the external member or the external member organization, so that they are also bound by law in terms of protecting the information, confidential information that is there with them. And I see another question by Pratiksha, who says that how often should PoSH trainings be conducted for ICC members? Do we just have to conduct it once or every month or so? Okay, so law does not specify the frequency in which the session needs to be conducted. Law says regular sessions need to be conducted. It depends, Pratiksha. This is a question. So one is mandatory. Imagine that, one you have to do within the organization. Apart from that, depending on the size of the organization and depending on how many cases they are receiving, organizations do more trainings as well. So if you will go ahead and you will see a lot more information out there for all the BSE top 100 listed companies. So listed companies have that requirement to also put the details of the cases that they have received in a year of sexual harassment in their board reports, right? So then if you will see a lot of these big MNCs, because with more members and with more awareness, they receive a lot more cases. Therefore, when you receive receive a lot more cases, ICCs have a lot of practical questions about handling cases. So I've also seen that big organizations conducting IC trainings every quarter. So every quarter what they'll do is that they'll do one session so that the IC is updated with respect to any changes in the law or any new thing that they are facing. But I personally suggest all ICCs to have 2 sessions, mandatory sessions in a year, so that within an approximate gap of 6 months, so that any update in the information that they have or any new information that they received, they can then check with the trainee and trainer, and they can get their doubts cleared.
Right. There are a few more questions regarding ICC. So I think we can cover them once we come to the procedure part of it. Right?
Sure.
So we'll get these questions, right?
Sure.
Moving on to the very substantial part of this law, what constitutes as a sexual harassment, and where what is a workplace. These some important things are mentioned in the definitions part. So if you can throw some light on the important definitions and what do we mean by sexual harassment, and what do we mean by workplace?
Yeah. Okay. So these are very, these are very detailed conversations, but I will touch upon it quickly, and I mean, with as much information that I can give in a limited period of time. So, Akshay, there are 3 important conversations. There are 3 important definitions under the law that one has to remember, because this particular law goes beyond every other conventional labor laws in terms of those definitions. Okay. So one is the definition of who can complain and who can they complain against. Second definition, as you said, is of the workplace, and third definition is of sexual harassment. So first definition, let's take up the first definition quickly. Who can complain and who can they complain against? So the law defines aggrieved woman, and the law defines employee. Okay. And they have, what the law says is that an aggrieved woman who complains to the organization and who has the right to complain to an organization's IC can be an employee of the company, or it also can be somebody who's not an employee. So basically that means that it could also be a person who's a visitor to the organization, or could be a client, or could be somebody who's interacting with the organization. So this is as broad as possible. And one of the best definitions, one of the best examples of a visitor to a workplace that I can give to the audience is, imagine that, when you're going to see a movie and you've gone to see PVR, in PVR, you are the visitor. And with respect to taking up services of PVR, then and people who are working there, they are the employees. So if you as a visitor get harassed by somebody who's working at PVR, so let's say when you're taking the popcorn, people who are working behind the kitchen counter, people who are working as guards, etc. In case a visitor gets sexually harassed by one of the employees of PVR, at that point of time, even though you are a visitor, you can complain to the ICC of PVR for against that employee. So that's how that's the entire reason behind it has been to make sure that the definition is broad enough to provide an access to complain to every woman who faces sexual harassment vis-a-vis a workplace. Now we have to look at the definition of employees. Even with respect to the employees, the definition has been expanded. So it does not mean only the regular full-time employees of a company. It also refers to trainees. It also refers to people who are working on contractual basis, people who are consultants, people who are working in terms of, people who are coming from third-party agencies. And to the extent that the law even says that it does not matter that you are getting a remuneration or not from the organization. So which means that if, let's say, all the NGOs, etc., where people are volunteering, in that case, even if they're not getting any money from there, but let's say they face harassment, sexual harassment, while they are in their voluntary capacity while working in an organization, even there they can complain to the organization on sexual harassment at workplace. Another aspect that I would just quickly want to throw light on is the fact that the law also introduces domestic workers as complainants under the law. And the fact that for a domestic worker who comes to your house to clean and cook and do all sorts of things, they are also, for them, your house is the workplace. So domestic workers can also complain for sexual harassment at workplace, but for them the complaint committee is different. For them, the law says that the district officer that I mentioned before, the district officer who's set up at the district level, they need to set up a local complaints committee whose composition is completely different as per law. So in that sense, what it does is that the local complaints committee, which is set up at the district level, domestic workers can also complain there. So that's how broad the definition of employee is. So which means that, and let's come back to, an organization. So which means that in an organization, people who are working full time, people who are working on a consultant basis, even the interns who are visiting the organization, let's say they face sexual harassment, and I'm talking about women who are working in these capacities. If they face sexual harassment by another employee of the organization, then they can file a complaint of sexual harassment within that organization and to the ICC of that organization. That's how broad the definition is. Second concept is of workplace, and as we all know, the definition of workplace has gone through so much change in the last 1 year, given the fact that we are not just constrained or we are not just thinking of workplace from the perspective of the four corners of the office that we are working in. It's also a hybrid environment and a completely online environment that a lot of us are facing. One has to remember that those are also your workplaces. So as per law, the definition of workplace says that everywhere that an employee of the organization goes in the course of their work is their workplace. And with that broader definition, we can categorize workplace into three categories. One is your primary workplace, one is your extended workplace, and one is your virtual workplace. So primary workplace is, the term itself clarifies it, right? Primary workplace basically means the office where you go and spend your time. So between 10 to 7 or whatever your office timings are, that office where you're working, obviously that is your workplace. So any incident of sexual harassment that comes there, and you can complain to the IC for sexual harassment at workplace. Now, the second category is your extended workplace. Now, what is extended workplace? Extended is wherever you are going in the course of your work and you're moving around and you're visiting in the course of your work, that is extended workplace. Examples of extended workplace are the conferences that one is attending, all the events that one is attending. If you're traveling for work because you're, in terms of going to another city. And the most important thing to see is that why were you there? You were there because your organization had sent you in an official capacity in that work, right? So therefore, that becomes your extended workplace. So let's say, for example, a woman has gone to, let's say woman from Delhi has gone to Bombay for an official work, and she's staying in a hotel, okay, and she faces sexual harassment from the employee of the hotel. In that case, even though it becomes third-party harassment because it's a third-party harassment, but still she has the right to approach her organization and tell them that this is where I got harassed, and the organization's job is to support and make sure that all support is provided to the woman to help to address those to address any concern and help her in handling that complaint. So that's how we have to look at these definition of the workplace that is there. And another very critical example of extended workplace, which is very crucial for everyone to understand, are these office retreats and office parties, New Year parties, anything that happens within the organization, right? So because these are company funded parties and company approved events, people generally, I have seen, in my experience, I've seen as an external member for organizations, a lot of cases coming from that area. And because people tend to forget, when they're enjoying or when they're drunk, that, this is their workplace, and a lot of misbehavior happens in such scenarios. So in that case, also very critical for organizations to explain to employees that, hey, if there is a company event that is happening, that's your workplace. It's not your personal playground. So you have to maintain decorum and you have to maintain your professional standards there as well. So that's how, broad the definition of extended workplace can go. Third example is obviously, your virtual workplaces. And I think virtual workplaces, now we have a lot more idea about what virtual can mean, right? All of us are in some way or the other using some form of official communication online tool in our organization to communicate with our colleagues and communicate with clients and etc., right? So basically phone calls, SMSs, WhatsApp, all the official communication channels that you're using. Let's say you're doing a meeting with your colleague on Zoom, and in that case, that Zoom meeting is the workplace. So a lot of cases in the last 1 year have come up because remote working environment doesn't mean that PoSH is not applicable. Sometimes people, I think, forgot this, and people thought that, remote working environment, because I'm working from home, that means PoSH is not applicable. But that's not true. PoSH is also applicable while we are working at home, because you're doing your official capacity, you're doing your work as an official capacity, right? So in that case, if you are working with your colleague and some untoward cases happens to a woman, or let's say if a man is doing something inappropriate or saying something inappropriate, in that case, that conversation that happened on, let's assume, Zoom, will be considered as sexual harassment at workplace, and a woman has the right to complain. So virtual workplaces is very important in terms of, we see a lot of cases coming up where people have been sending lewd messages or pornographic texts, and things that are happening on WhatsApp in terms of official communication groups that are made up, or even on a one-to-one basis. I have seen a couple of cases that came up last year where senior, or for example, if the manager of a level person of an organization was behaving very inappropriately on a Zoom call with a woman, and he used to call her for all the late night Zoom calls, and he used to dress inappropriately or touch himself inappropriately, and the woman had to come and complain. And that's the thing. People forget that there is a line that does not need to be crossed, and they forget that that's your workplace. So therefore, very important to understand that workplace is not just limited to your primary workplace. Workplace right now definitely extends to your remote workplace, as well as extends to extended workplace definition that I just explained. The third definition that is very important is, Akshay, sexual harassment. I think that I'll quickly touch upon this because it's very important for us to understand what is sexual harassment at workplace, right? So we have understood women are covered. We have understood what our workplace is. One also needs to understand what is sexual harassment. So the law gives 5 broad parameters to define sexual harassment. Interestingly, this is the same definition of sexual harassment that is there in the definition of sexual harassment under section 360 of IPC as well. So it's the same definition of sexual harassment. So the law defines 5 broad parameters, and if you'll hear it out, you will realize it's broad because it gives a lot of opportunity to lawyers as well as to ICs to interpret, even for the women, because it has to be seen from a fact-to-fact basis, right, on a case-to-case basis. So the first definition, that first parameter of sexual harassment is physical contact and advances. Therefore, and that's basic to understand. Any inappropriate touching, hugging, in serious cases, assault or grabbing somebody, these are things that come within the definition of physical contact and advances. The second definition of sexual harassment is demand or request for sexual favors, okay, and which is what basically is quid pro quo, which means this for that. So the law says that, because there have been a lot of cases that come up where demand has been made or request has been made to a woman for sexual favor in return for something. So there are 2 elements attached to it. One is that there could be an element of, if you will, do what I'm asking you to do in terms of the sexual favor, then you will get promoted. Okay, so that's a positive reinforcement of the same, that, I will only advance your career, or your career in the organization will only get advanced if you are, listening to me in terms of the sexual favor that I'm demanding. The second is that if you don't adhere to, or you don't listen to what I'm, or if you don't do what I'm asking you to do, in that case, there will be a problem for you. Like, your position in the organization will be severely hampered. And both type of cases come in. So demand or request for such sexual favors happen in organizations, I will not generalize it, but typically this has been seen in senior junior relationships within organizations, where mostly people in managerial positions are demanding sexual favors from people who are junior in rank, from women who are junior in rank, either in the pretext of offering growth or in the pretext of threatening their position in the organization. So this has to be, this is something that comes up, and this is why a lot of organizations in recent times are also framing dating policies within organizations, because it's important that romantic relationship within organizations as well has to be made sure that organization takes a stand on it, because a lot of cases happen where two people are dating and there is a fallout, and that comes out on the organization, and then these cases become very messy to handle. And in a lot of organizations, dating policies define that how seniors in the organization cannot date people who they have a right, they can comment on their performance, or basically somebody who they are holding a managerial position over. So a lot of new things are happening vis-a-vis this as well. The third and the fourth thing that the law defines it as is making sexually colored remarks. So basically, making any joke, sexual innuendo, sexual anecdote, swearing, because as you know, a lot of Indian swears are sexual in nature. So swearing in front of your colleagues, all of that comes within the definition of, the making sexually colored remarks. The fourth category that the law says is basically showing pornography or any such text. So basically sharing pornographic text, etc., with the team, with any person in the organization, or sending them lewd messages on text. These things are also prohibited. The fifth way it defines it as any other physical, verbal, or non-verbal conduct. So physical, obviously, we have understood. Verbal, we have understood. Non-verbal basically refers to what women face very frequently in public spaces, which is basically staring, leering, and stalking. Right? So stalking happens, and that actually also extends. You'll be surprised to know how many cases of stalking comes up within workplaces, and cases of staring comes within workplaces, where a woman is feeling extremely uncomfortable because one person in the organization has decided to stalk them or follow them around the workplace or while they are going home, and it creates a very dangerous scenario for a woman, and or consistently staring at them, making them feel very uncomfortable. And that's very important to understand. So these definitions of sexual harassment is very critical to understand for everyone. That and two things I'm going to add to the definition of sexual harassment, and that comes one comes from the legal principles, that the law says that the intent of the basically your intent does not matter, the impact matters. So which means that a lot of cases come up where I have heard respondents who are basically the accused saying that I did not mean this, or I said it as a joke, or it slipped out of my mouth. So in that case, the law says that even if you are saying your intent was not there, but you also have to measure it vis-a-vis the impact of the sexual harassment on the woman. So it is very important to remember that. And second thing is very important to remember that there is a line, and there is a line versus in terms of consent versus non-consent, and consent given is not absolute, right? So if you receive consent, one doesn't mean that's an absolute consent. It could be taken later on. So for example, just to give you an example, people have friends in organizations, right? They're joking around, and there are a lot of jokes happen, and sometimes there is an assumption that, okay, this person is listening, this woman is listening to my jokes, so she's going to listen to everything that I'm going to say. But no, that's not there, because there's always a line. So if you start making sexual anecdotes and sexual content in your jokes, and the other person is feeling uncomfortable, then you can't go and say that she used to laugh at my jokes earlier. So things like that. And again, there is no strict definition here. These are broad parameters. Everything has to be seen on a case-to-case basis, which is where the job of the ICC and the external member comes in terms of handling such investigations.
Right. So yeah, we are clear with what sexual harassment is and what workplaces are. But what is that now that employer is supposed to be doing? What procedures is he supposed to establish? What is his exact responsibility here?
Okay, so I think so employers have a lot of these compliances that they need to do as per the law. I will define certain very, very crucial ones. And I had said that in the very beginning also. So I think I'll divide the employer compliance into three parts. One is the documentation part, second is your training part, and the third is the ICC and the redressal mechanism part. Okay. So documentation, when I say documentation, it means that, organization has to, the most important compliance measures are that the organization needs to have a PoSH policy in the organization. The PoSH policy basically is the document that helps organizations and that helps employees of the organizations understand what is sexual harassment at workplace, important definitions, and what happens when there is a complaint, procedure, what is the next step, and what are the procedures that are applicable in terms of sexual harassment complaints. So the PoSH policy covers all those details, and that's a mandatory thing to have in an organization. Second thing the law says is that you need to have notices. So you need to put up notices within conspicuous places in the organization, which defines the workplace, which defines who is the ICC and what are the steps that the organization is taking. So this is being done because, as I said, any visitor to the organization can also can also file a complaint to the IC. So in that case, what happens is that, if you put up a notice and if you put up the details, then as per those notices can help people know that, there's an the organization has an IC. Other documentation that is required is an annual compliance report. So the law says that as every calendar year, so which means between January to December of a year, that is a calendar year, annual compliance report needs to be filed in the next subsequent January of the next year. Basically, for the year 2020, January 2021, a lot of, and so basically annual compliance reports were filed under PoSH Act. And there is a format, there are parameters given in the PoSH rules itself. It says that the annual report should define a couple of things. It should say what is the number of complaints that were received in a year, how many complaints were addressed by the organization, how many complaints were left unaddressed by the organization, and how many sessions were conducted for the IC and for the employees. So these are the specific things, and the annual compliance report needs to go out to the district officer of the district where the organization is based. So that is how so that is where that is also a mandatory provision. So just for everybody's information, state of Telangana and Noida, Greater Noida, basically they have now set up an online mechanism where you have to upload the annual compliance report under PoSH Act. So if you have, or you're advising any organization which is based out of Telangana or Noida or Greater Noida, please go and check out the website of the state government, where they have now made the process online in terms of adding the details of the ICA and uploading the annual compliance report there. But rest of the states have not done it. So it's a postal mechanism, basically, where you post to the district officers. So this is what employers' job is to do. Second thing that employers have to do is conduct trainings. They have to make sure that they're conducting mandatory trainings every year for the employees and for the ICs, as I have already discussed. And the third thing is, the most crucial thing is, set up ICCs in every office of the organization. So the law is very clear about it. Every office of the organization, if you have 4 offices, you need to have 4 ICCs, basically. And for smaller organizations, we can look at different ways of complying with this. But for larger organizations, it becomes very important, because imagine you have 4 or 5 main offices across India, and there are like some 100-200 people working in each office. So the law says you can't just set up one IC for each office. For the entire organization, you need to set up different ICCs for different offices. So that's what the job of an employer is to do. Another thing that I'm just going to add on quickly is that the law says that if, as a woman, if you are if you're filing a case of sexual harassment at workplace before the IC, you also have the criminal route available for you, that you can also file a complaint in a police station against that person. So the law says that if a woman chooses to do that, then the organization needs to provide her all mechanisms and assistance in terms of filing that case as well. So that is also an employer's responsibility, mandatory responsibility if the woman chooses. And even in case of third party harassment, like the example that I gave earlier, that you've gone out to work in a for a meeting to another city and you're staying in a hotel, and the hotel employee sexually harasses you. In that case, the woman has the right to go to the organization, and organization has the responsibility to support her in filing police complaints if she wants so. So that's what also an additional mechanism, that is additional responsibility of an employer.
Right. So there was a related question on training. Should the regular employees be trained in the proceedings of ICC? Who should be trained?
No, I've already covered this question before, guys. Regular trainings, I said this, regular trainings definition is not provided in the law. It says that you have to conduct regular mandatory sessions. So one or two, basically one is definitely you have to conduct in a year, but depending on the number of cases that you are getting or number of cases that ICCs are getting, you can determine within the organization how much support the ICC needs. So it could be that you can have 2 sessions in a year. Organizations do quarterly sessions as well, because let's say for much larger organizations, they receive a lot of sexual harassment complaints, and these are organizations that I'm talking about which have 5,000, 10,000 people. So they receive very frequently complaints of sexual harassment. In that case, they do like quarterly ICC trainings, because you can imagine, right, they're getting so many cases, there are a lot of questions that come up for ICC members. And Akshay, the next part of the question was who should be trained, right?
Yes.
So IC should be trained. The IC members who are appointed as the ICC committee, as per the law, it is mandatory to train that IC1. And secondly, it is also important to conduct a sensitization session for all employees, irrespective of their gender. Just to clarify for all of you, it's a common myth that organizations only need to conduct sensitization trainings for women employees. No, they have to conduct sensitization sessions for all employees. So you need to remember this is not that trainings only have to be done for women employees. It should be for everyone working in the organization across level who should be attending the sensitization training being done under the law.
By when should the annual report be sent to the authorities every year in the event that district officer, labor department haven't received the report? Is there in another body that we can submit the report to?
Okay, so a very valid question actually, because as I said, only Telangana, Noida and Greater Noida have an online mechanism for submitting annual report. Rest, they don't have it. So I will suggest 2 mechanisms how to do it. With respect to the timeline, because you have to submit the annual report in a calendar of a calendar year, so which means January to December of a year. So what happens, the timeline mostly is people generally file their annual compliance report till 31st January of the next year. So for example, for 2020, annual compliance reports under PoSH was filed by 31st January 2021. Now, where do you file it? See, the district officers have been appointed. You have to find that information online under PoSH Act. If in case, and just to clarify, majority of the district officers that are appointed under PoSH Act are either DMs, like district magistrates of a district, or district commissioners of a district. So check that information. Second thing is, you send a postal, the annual compliance report via post. Maintain the postal receipt and maintain also the tracking details of the annual compliance report reaching that office. You will never get a acknowledgement from their side, but in terms of compliance, you should always have the postal receipt and the tracking receipt for the same. In case you don't, if you find out that there was no district of there's no district officer under PoSH Act that has been appointed in the district that your organization is at, then send that annual compliance report with a covering letter to the Women and Child Development Department of the state. So for example, if you are in Delhi and Delhi, or so for just for information, I am based out of Delhi. Delhi, all the 13 districts have district officers appointed. But let's assume that they did not. Then what I would have done in that case is that I would have sent the annual compliance report of the organization with the covering letter that, you know, I don't have details of the district officer of my district under PoSH Act. So I'm submitting the report to the Women and Child Development Department of Delhi as a state. So you submit that, but always remember, maintain postal receipts and tracking receipts for the same.
Right. I'll just check if there is any other question. Sure. How about emails?
How about emails, meaning?
If you can mail them the reports.
Yeah, okay. So I would not suggest emailing because only from a practical perspective that emails are generally, for these government bodies and for these government agencies, a lot of times I've seen wrong emails. Okay. And the bounce rates are very high. So even if you're emailing, let's assume that you have found the right email ID, please just don't email. Always send out in the report during with post as well.
Right. If there are no similar question on same topic, I'd move on to the next question. So yeah. we discussed that an employer has a lot of responsibility in this area. So what happens if employer himself isn't accused in a case of sexual harassment?
Correct. Very, very critical question, Akshay, that you have asked here. Very important to differentiate also. So, guys, if you are an employer, so if a case of sexual harassment within the organization is against the employer himself, so which means the employer means the person who is running the organization, right? People who basically have the hire and fire capacity, people who are running the organization, so basically CXOs of the organization or listed directors of a company, etc. Then the case against that employer will not be taken up by the IC. The case against the employer has to be filed by the woman in that local complaints committee. So if you remember in the beginning, I had also mentioned that there's a local complaints committee that needs to be set up in a district level by the district officers. So the woman has to take the complaint there. Reason being that the ICC will be biased, and the bias is identified right from the very beginning, that if the case is against the employer itself, then the ICC, because it's the same employer who's also responsible for hiring of the people who are part of IC and who are responsible for firing them as well. So IC will be biased, so IC cannot look at cases of the employer. Unfortunately, I'll just like to add a line here as well, that the compliance of the law at the district level is not as fast as one would have expected. So a lot of local complaints committee at the district level, there is no information available online, or there is no such details of constitution of the same. So sometimes it becomes a problem for women to find out those local complaints committee. But what I would suggest is that even if something like this happens for anybody, then in that case, please go to a direct court route, or also you can think of a criminal complaint against in a police station, because in case if you don't find the details of the local complaints committee. Another option is that you can also write to 𝗍𝗍𝗃. So Government of India has released something called 𝗍𝗍𝗃, and it's 𝗍𝗍𝗃.nic.in, where if your complaint is not getting redressed by the organization, then you can file a complaint to the Ministry of Women and Child Development directly under 𝗍𝗍𝗃 as well. So take up all the routes like that in case you can't find out the local complaints committee.
Right. So another quick question. So we just talked about employer being an accused. So can a woman be an accused in a case?
Again, a very pertinent question that you have asked, Akshay, because something very recently happened as well. So this was something that was always part of the interpretation of the law, but that has also been upheld by one of the high courts. I'm just missing out the name of the high court. You can find that information online. That so complainant's gender has been defined, right? It has to be a woman, but the respondent's gender has not been defined. Therefore, it means that the respondent can be a person of any gender working in the organization. It could be a man, it could be a woman, or it could be persons of other genders as well who are working in that organization that a woman can file a complaint against. So, the definition, this judgment has also come out from one of the high courts, that a woman can also complain against a woman as well, or a man, or persons of any gender.
Right. So, in case an order has been passed by ICC and the aggrieved woman is not happy with the order, so what remedy is there? What remedy can be there?
Got it. So, two things I would like to specify here for everyone. One is that, the order of the IC. So basically, the end result of the ICC conducting its inquiry or investigation in a sexual harassment complaint is that they take out an inquiry report. Okay. And the inquiry report is like a mini judgment, where basically IC has investigated the complaint, look at witnesses, look at all the interviews of complainant and respondent, the cross-examination that has happened, any evidence that was submitted, and then they take out the conclusion whether there was a case of sexual harassment or not. Now, this inquiry report, at the end, ICC has the responsibility, has the mandatory responsibility to give a recommendation which is binding on the organization. Okay. And the recommendation can range from a warning or issue, or asking the person to issue an apology, to termination as well, and also order the person, the respondent, to give a compensation that was determined on certain principles to the woman, against whom the sexual harassment has happened. So when the IC takes out an inquiry report, then the management has to implement it. There is no reason and there is no power given to the management, or there is no appeal that lies with the management, that they can change the ICC's recommendation. So the ICC's recommendation A is final, and the management has approximately 60 days to implement that, up to 60 days to implement that. Now, the law says that from the day the inquiry report is generated, if the woman or even the respondent has a problem with any part of the inquiry report, they have 90 days to complain to the appellate authority appointed under the law. Okay. Now, the appellate authority appointed under the law basically is the authority. I mean, I'm going a little bit technical here. So the PoSH rules go and define the appellate authority to be something that has been appointed under the Employment Standing Orders Act of 1946. So it's very important for women to first consult with a lawyer and understand where they can file the appeal, and also file the appeal in that forum. And mostly it's the labor and industrial tribunal, industrial tribunals that are set up in different cities that have the jurisdiction to handle such complaints. But my point of consideration for everybody to remember is that that the report of the ICC cannot be challenged within the organization, because this has again been one of the myths that have been perpetuated, that organization have the right to handle appeals also, the first level of appeal against the IC inquiry report. That's not the case. It has to go to the court of law. So sometimes what happens is, Akshay, that we have seen that sometimes women are not able to identify, or sometimes there is no appellate authority in their specific place where under the Employment Standing Orders Act. In that case, people have gone ahead and filed writ petitions directly to their respective high courts, challenging the ICC's inquiry report as well. So these are the different mechanisms that are available for a person if they have a problem with the inquiry report.
Right. Before moving on to the next question on remote working places, just one clarification. I guess there were some confusions with that. So if an organization is 100% voluntary organization, so every employee there is working without salary, let's say. So would there be an employer-employee relationship, and can we implement PoSH there?
Yeah, definitely. And just to be clear, I don't think that there can be any organization which has a complete 100% composition where everybody is working on a voluntary basis. What I think it means is that there is a very small team, let's say maybe 2 to 3 people who are managing everything, and then there are people who are working on a voluntary basis in the organization. So in that case also, let's say one of the volunteers face sexual harassment either among themselves or either vis-a-vis each other or maybe from a third party. In that case, the question is, why were they there? Was this sexual harassment at workplace? Did they face sexual harassment while working for that organization? If that is the case, that they face sexual harassment while working at the organization, in that case, they will come to the organization's IC to file a complaint. This is very, very clear. So if you are an organization who has a very small team, but you have a huge voluntary network as well, so which makes it beyond 10 at any given point of time, then you should set up an IC, because that's very critical for you. Because if there is something that happens between two volunteers at workplace while doing the work for you as an NGO or any other organization, in that case you have to handle it.
All right. So moving on to the next question. So a lot of people are working from home now. We have a new remote working culture. So how do we deal with that? How can organizations make sure that it's a safe working atmosphere? Because you cannot monitor things physically, right? So how are organizations doing it? How can we implement PoSH in these times?
So it's been a little, it's been difficult for the HR team and for the legal team of an organization or teams which were looking at implementing PoSH. It's been a little difficult, I would say that, in terms of implementation, because I think nothing can replace a face-to-face sensitization session. I was also doing a sensitization session today morning on Zoom, and that kind of connect that happens in terms of answering questions and the connect that builds up, that is not possible. But that doesn't mean that it's not it cannot be done. I think what organizations are doing is that, I think couple of things, I would say top 3 things that organizations should remember while implementing PoSH at their remote working place is conduct sensitization sessions, because people have moved online. See, the minute you start changing the structure of the organization, and in this case, this was a very, very critical change that had happened, right? People had automatically, in a very brief period of time, had moved from a physical space to a virtual space. So in that case, organizations, the first responsibility is to make sure that you have a sensitization session that you are conducting, and conduct regular ones. Like, if don't just do one, do regular sensitization sessions, maybe every quarter or maybe within 6 months also is fine. But for people to understand that, hey, PoSH is still applicable on you. Remote working environment also, you need to maintain professional ethics and standards, and standards of professional behavior. So sensitization sessions is very important. Second thing that is very critical for organizations to do is make sure that emailers and newsletters and information that is going out, you also include details of PoSH implementation as well, which means that you also keep informing employees of the ICC formation, the details of the ICCs of the organization, where can they approach the ICC members in case they're facing any issues, and the PoSH policy. So this, because we talked about one of the requirements under law, that which was a notice that has to be put at conspicuous places, right? Now, if nobody is going to office, then where does the notice requirement goes? So the notice requirement also moves online. So what I'm advising a lot of organizations these days is also to make sure that their team who takes care of the emailers and information traveling within the organization, they should also build in these monthly or quarterly information about PoSH and about information about the ICC and PoSH policies that need to go out. The third thing that organizations need to do is basically make sure that there is a clear-cut communication that goes out to people about about PoSH policy and about other HR policies as well. So third thing is to, you make it accessible. You make all your policies accessible on a common drive, or on a common, if you're using Slack, or if you're using any other, communication channels. These all channels give you an opportunity to keep one place where all your HR policies and everything are available. See, my point is that even in remote working place, I think the conclusion is that workplaces need to understand that just because things have moved online, and team members have to understand that because they are working from home does not mean that standards of professional behavior need not to be maintained, and therefore lines get crossed. So for example, as I gave the example, right, Zoom meeting you're doing late at night, and you're also behaving inappropriately, and you're dressing up inappropriately, that kind of cases are coming up because people are crossing lines there, because they are saying कि हम लोग घर पे बैठे थे, right? That doesn't make any sense. That doesn't make any difference. You still have to make sure that you still have to make sure that your you are complying with the law, and organizations have to teach that and have to make sure that information goes out there.
Last two questions I'd like to take. One has been Karan's question. He's been asking from some time. Can we please get what is extended workplace? What happens if a person is visiting, an outsider is visiting and he harasses an employee? So how would PoSH be applicable here?
PoSH will be applicable because the employee will file a complaint to the IC of the organization saying that within workplace I got sexually harassed, and then it is the organization's job to reach out to that member, to that person who has who they are accusing of sexual harassment, and bring them in for questioning in terms of the PoSH investigation procedure that is applicable. A more practical way, because this is a third party we are speaking about, and we are talking about an internal employee of the company which got harassed by a third party, by a visitor of the organization, then it's very important for organizations to take two proper steps. One is that they should help the woman to file a police complaint immediately against that person, and the second thing is that if it's a visitor from any other organization, then you should contact the organization and say that we have received a complaint of sexual harassment, and you should involve the organization in terms of handling the complaint together. That's how it's done. That's how practically it's done.
Right. Another question was on maintaining privacy of the complainant. Yeah. Well,
okay. So a great question, because the law says that so absolutely right. Confidentiality and privacy of the complainant is a very critical issue here. However, one has to understand that the privacy of the complainant cannot be maintained before the IC and before the accused, which means that you cannot file anonymous complaints under the act just to maintain your privacy, or you cannot tell the IC, a woman cannot tell the IC that please do not reveal to the accused who I am naming in my complaint that I have filed the complaint. That cannot happen. But there is another provision within the law which is basically putting confidentiality obligations on the entire organization. It says that details about the accused, details about the victim, details about the IC procedures, and whatever is the investigation going on, these are all strictly confidential. If there is any leakage of that kind of information anywhere, then the ICC has the power to fine that person who's leaking such sort of information. And the law also puts a fine of 5,000 rupees. So IC can fine somebody who's leaking that kind of information and is not maintaining the privacy of the complainant, and fine that person 5,000 rupees. And I have known organizations who have gone beyond that, and they have also fined employees 50,000 up to 50,000 rupees because confidentiality obligations were breached. So it is totally dependent on the organization how they're enforcing, because it's easy because it's written in the law, right? But it's very difficult to be implemented. Also difficult to be implemented because organizations generally ignore this confidentiality obligation within the law. So it's very important that confidentiality obligation should be enforced by the ICs. And if as a woman, or as an aggrieved woman, or if as a respondent you know that that information about the IC proceedings were being leaked and it's been given out to different people, then in that case you should go to the IC and tell them that this information is getting leaked out, my reputation is at stake. This process was supposed to be completely confidential. So therefore, it is very important that the IC should enforce that rule. And it's very critical, these are small things that matter. So for example, confidentiality in an organization, within an organization, when they're conducting investigations also, it's very difficult to maintain confidentiality. So very important, like couple of things that, I tell ICC members is that, you need to make sure that you do investigations in an area of the office which is inaccessible to general public, or, which is a little quieter, because you don't want investigations to keep going on, and then people to notice that, there's some meeting that is continuously happening in another room, right? So these things, these problems used to happen a lot in physical environments. Online environment, it's not so it's not difficult at all, because one is very specific here. But confidentiality and privacy of the entire proceeding is important to be maintained, and confidentiality obligations is given in the law itself.
All right. Absolutely. The last question.
Yeah.
So, just a second.
Yeah.
So what happens if? I'm sorry. Just a second. What happens if a complaint is proven to be false?
Okay, so false complaints are also covered under the law as well. The law says that if there is a false complaint, so for example, if there was a complaint where there was wrong information that is given, okay, basically tampering of evidence that has happened, wrong evidence that was given, the complaint was entirely false, then if the IC has to do an investigation on that as well. So let's say there was a complainant who had filed a case against the respondent, right? And the respondent also comes back and shows proper, but this requires evidence, okay? So respondent has to show evidence that this was false complaint. In that case, if they show the right evidence, then ICC has the responsibility, mandatory responsibility under the law, to conduct a reverse investigation on the complainant, and then they can recommend the same kind of recommendations, punishments that they can give under PoSH Act, they can give on the woman as well. So that is how false complaints are being dealt with. But the law says that the inability to provide evidence is not a false complaint. So one also has to remember that, because a lot of cases are he said versus she said. They happen between two people, and there is like evidence is difficult to gather at right in the very beginning. So in that case, a person cannot say that she does not have any evidence, so the complaint is false. No, you have to carefully show that the complaint was actually false, or the complaint there was a wrong evidence that was filed, or there was a tampering of the evidence that happened. Because you have to understand from a practical perspective, since a lot of cases happen at at the personal level between two people, then if we start penalizing women for not filing the evidence right in the very beginning, then they can't be taken as false complaints. But of course, with evidence, this can be taken as false complaints, and in ICC has the job to do a reverse investigation.
Right. All the questions are never ending. I guess this is a huge topic
this is a huge topic. Yeah, absolutely.
Right. So you have written a book on this whole topic, which is called Understanding Workplace Laws for Women in India. Can you tell us more about it?
Yeah, so I've been working in the area of gender law implementation, especially PoSH, over the past 5 years. And one thing that I noticed while working with a lot of organization is that there are a lot of labor law books that are available, or there are a lot of there are a lot of individual books on PoSH that are available, or there are a lot of labor laws books that are available which talk also about the labor law provisions in general and which are applicable to women. But there was no consolidated commentary in terms of which talked about workplace laws for women in India. So what we did was basically we wrote a commentary specifically on this topic, and it is a go-to book for anybody who wants to understand what are the women-related workplace laws that need to be implemented at the workplace. It is applicable, and it can be useful at an individual level also for women who want to understand that provision. And of course, it is helpful for the HR team and for the lawyers and in-house counsels, because they have to implement these laws at the workplace. So that's where the idea came, and we were very we are very grateful to Bloomsbury for giving us the opportunity to publish this book as well. And if anybody requires more information on IC procedures and inquiry complaints proceedings and everything, there is a lot, it is provided in a lot more practical detail in the book. I have distilled all the information and my experience of handling sexual harassment complaints in the book. So I've tried to make it a go-to book for, for implementation of workplace related laws of women in India. Just for everyone's thing, I'm going to just show the cover of the book here. This is how the book looks like, and I think Akshay has also given the link here. Please feel free to check it out.
Great, great. Thank you so much, ma'am, for taking out your time. So it was a great session, actually. So all the participants, if want to know more on this issue, you can obviously go and check the book. And you can also check our course on PoSH. Ma'am has been involved with the course, and it's a great course if you want to practice practice in this area of law. So thank you so much, ma'am. Thank you so much, everyone.
You're welcome.
Yeah.
All right. Thank you everybody for listening, and thank you for all the questions. And I hope I have addressed your queries. In case anybody has more, in case somebody has any specific question on what which I have not been able to handle here, what I would request is, you could contact me on LinkedIn, and we can take forward a conversation from there. So please, thank you for listening.